Hello and welcome to Bulletin 42. Two interesting cases are digested in the Bulletin. The first is St John and St John, where the application was for judicial advice. It's salutary because in the event the judge said that judicial advice wasn't required, and accordingly the costs of one of the parties, the party who had notionally at least caused the need for the application, was ordered to have her costs paid by the executors. Briefly, the appropriation issue was resolved because the executors had the power, without the consent of any beneficiary, to make the appropriation. So, end of story. And the other issue was whether by the person who had an interest that was terminable on life or remarriage, who relinquished it, surrendered it, whether it meant as a result that the remainder persons took forthwith, and the judge said yes, they did. So therefore there was no need for judicial advice, and there was a penalty in effect by the executors having unnecessarily engaged the court in something that was straightforward as far as the judge was concerned. So before getting judicial advice, it's good to think whether in fact it's strictly necessary, or in fact are the powers already there and they just have to be exercised appropriately. For example, in making the appropriation, there had to be an assurance that there was equality preserved as a result, of the rights of the beneficiaries preserved, so there could be no argument that they were treated unfairly or unequally in this instance because of the appropriation that was undertaken. The other case, it's the case of Ratswold and Court. There it was an offer of compromise that in effect you might say was successful, because at the hearing the plaintiff received more than the offer of compromise that had been made. So from the date when the compromise was provided, or the offer of compromise, the plaintiff got indemnity costs and got costs on an ordinary basis up to that time. The only complication was that the estimate that the plaintiff had given of their costs were in fact an underestimate by about $44,000. Nonetheless, the defendant's costs were still about $10,000 more than the plaintiff's costs. What the defendant wanted to do was to have the judge cap the costs of the plaintiff to the estimate, the lower estimate that they had already provided, so that in effect it would be more for the defendant, and the court was not prepared to do that. The judge said that if they capped the costs as he'd proposed, then the plaintiff would have received less than what was intended for them by way of provision. It's a family provision case. So two interesting cases, both of which I think have some lessons in them. Hope you enjoy reading the Bulletin. Thank you.